Good evening. This is Laws 12062 Alternative Dispute Resolution. We're in week number 7. It's a big week. We're dealing with the general topic, the broad topic of other dispute resolution processes. The discussion tonight is based around Chapter 5 of Spencer, the textbook, and we deal with a number of issues. It's fair to say that I have not yet once had a client come to me with a specific request for me to, for example, make arrangements to engage a dispute resolution advisor, or to set up a scheme which involves partnering, or have something which involves some early neutral determination. The point that I'm making is that clients look to you for guidance in terms of not only the way in which they should embark on alternative dispute resolution, but the appropriate procedure to adopt for their circumstances. That's not to suggest that there is a one single answer which is correct in any given case. Different people may have different views, and the type of alternative dispute resolution process that's adopted may also be a reflection of the circumstances of the client or the personality of the client, or it might relate to the nature of the business of the client, or it might relate to the relationship between your client and the other side. So there are a range of factors that you need to take into account. So when you're reading the material and when you're thinking about what we're discussing tonight, it's important to put it in the context of initially the exam and then the broader practice of ADR beyond the exam. As you know, the exam will not be an essay-style question. You won't be asked to provide the advantages and disadvantages of, say, a dispute review board. What you'll be asked to do is consider a factual scenario where there'll be one or more people who who need some ADR, and your role will be to identify what you believe to be the appropriate ADR process, explain that process to the client, give the client some indication as to the advantages, the disadvantages, the costs, the benefits, the alternatives, and in that regard, during the time that you have for answering the take-home exam, I would not only encourage you, I would certainly encourage you to contact people in the industry, check out websites, think about the appropriate costing, because it's meant to be, if you like, a real live scenario. And it may be that you're given a budget from the client. The client may say, in relation to this particular dispute, I can give you $10,000 to assist me in resolving this. So you need to think about how you might spend that money in accordance with the budget. All right, so with that in mind, let's talk about some of the issues. You would have seen that I raised a number of questions in relation to what I think we should consider tonight. And during the course of tonight, I want you to think about something which is in your textbook at page 2, right at the start. And I'll just open it up, and you'll see that there's that graph. And that graph, which is very helpful, and I refer back to it quite often, is a commentary by David Spencer as to the type of ADR process that one is adopting, and essentially it provides that there are different levels of involvement of the disputant, and there's a difference between the formal and non-consensual interventionist models. So it's a different range of options depending on what would be best considered in a particular circumstance. So there's 14 there. There's 14 of them listed. Number 1 is negotiation. That is the, I suppose, ADR model that involves the greatest amount of involvement of the parties, down to 14, which is arbitration, which really takes it away from the parties to the greatest extent and is the closest to litigation. So have a look at that sliding scale and think about that in the context of what we're discussing tonight. So firstly, we'll talk about collaborative law. Now that's number 8 on that scale that I've talked about. So 8 out of 14. So it's kind of mid-range just slightly towards the more formal process, according to Spencer, slightly more formal than mediation. In terms of an overview, the thing about collaboration is that it is a process that is led by lawyers. It's designed to be led by lawyers. They act as advocates rather than co-mediators. So in that sense, it's more formal. It involves an informal conference or roundtable discussion, if you like, but with a twist. In some ways, collaborative law, the actual process, is mediation without a mediator. I know that sounds a bit odd, but there's a lot of similarities between the mediation process and collaborative law process. So according to Spencer, it's one step more formal than mediation, which means it takes the dispute away from the parties a little bit. It grew originally out of family law practice. It goes a bit beyond that in a very significant way, in that there is a commitment made by the lawyers who practice in this area to withdraw if the matter proceeds to litigation, and this commitment is in the form of a collaborative agreement. You might want to think about, why would you do that? Why would a lawyer choose to do that? What's the advantage to a client in doing that? Are there any thoughts as to what might be an advantage to the client in proceeding with collaborative law as opposed to a straight mediation, for example? To encourage agreement, says Brad, thank you very much. And it may be seen as encouraging an agreement because there's a commitment to get this resolved without litigation. There's a vested interest, a commitment from the parties straight away. Brad says to keep it out of court. It's a very clear, open, overt determination not to involve the courts in the process. That might be seen as advantageous to a lot of people. Any disadvantages? Why do you think parties are aware of small details of each other's case to assist with negotiations, says Catherine? Thank you. What are some of the disadvantages of collaboration? If you go into a collaboration, no third party, yes. Third parties, as we've seen in mediation, can help. So here, the parties are less advantaged. You might lose your solicitor if not successful, says Catherine. And I think that's a really important issue, because the client may say, well, now I've got to start again. I've got to explain it to everyone else. There might be a duplication if it goes to litigation. So thank you. So there's some of the issues to consider. Extra costs might be a burden as well. All right, so according to NADRAC, the collaborative law is where the parties are led by lawyers representing each of the participants, where it is agreed that the lawyers will cease to act for the client if the matter proceeds to litigation. So it's very focused procedure. Now, one thing that is common between mediations and collaboration is the existence, generally speaking, of an agreement. And we didn't talk about that much in the context of mediation. We just got straight into the mediation. But when you're advising the parties who are in need of ADR services, not only should you consider what type of ADR process is appropriate, but whether there should be some form of agreement, and if so, what goes in that agreement. And that would apply to collaborative law. It would apply potentially to mediation. And you might think about some of the extra things that are involved in that process. Now, collaborative law comes from family law. That's where it started. And when we're talking about family law, sometimes there's domestic violence issues. So if you're considering collaborative law or mediation as an appropriate way to deal with a family law dispute, you might want to think about whether there's a domestic violence order in place. And if so, are you promoting something that potentially causes your client to be in breach of that order inadvertently based on your advice? So think about that. Think about ways to get round it. It may be that you need to go back to court and seek a variation to the domestic violence order to allow for the parties to have direct contact in the context of an ADR process. It may be that you offer an alternative, such as an undertaking to behave yourself. That's if you're acting for the party which is affected, has the domestic violence order made against him or her. Okay, so collaborative law characteristics, I think we've talked about that. The agreement, lawyers are disqualified, if the process continues, it's technically speaking in collaborative law, the commitment from the parties as well as the lawyers is no one's going to litigation. It's going to have to resolve at this level, which might be a great thing, but in real terms, I'm not sure that that can actually work. The process includes allied professionals, so they too would be disqualified from continuing their work. And the process may include another person, a coach, who supports the parties and even their lawyers throughout that process. So it might be a person with extensive negotiation experience. Now you might think having a coach as part of collaborative law process is a good idea, but it might add to the cost as well. So it is a voluntary process, but I wonder if there are some other issues that come to mind with collaborative law. Now, some of these might be resolved by the agreement, but what if you are concerned, if you're the lawyer, and John says, is the decision binding? That's a very valid point. If you're the lawyer and you've signed to a collaboration agreement and your client or even in yourself raise an issue, I wonder if the other side are being fully honest in terms of disclosing documents to us. Should there be an out? Should there be an opportunity to go to court and seek some form of order for disclosure of documents? And be careful if you're going into a collaboration agreement without that ability to go to court. Perhaps you're setting your client up to a situation where he or she will not get the appropriate remedy because not all of the relevant information has been provided to you. At page 130, Spencer identifies the steps, identify the interests of the parties, identify the questions that need to be answered, gather information, create a number of choices, evaluate the options and refine them, negotiate an acceptable agreement, and closure. Gee, that sounds like mediation, doesn't it? And in going through that list, I suspect that you're thinking, yep, that's exactly what I did during my mediation session. That is for those of you that have already completed your task and uploaded your assignment. So that's very similar to mediation. So it is something which started with family lawyers, and there is a commentary by Ardar and Coombs, which is from a journal called the Legal Professional Post, ADR from Mediation to Collaborative Law. It's 2007, 18 Australasian Dispute Resolution Journal, 205. And in that quote, the authors make the comment that collaborative law is a process without mediators, yes, seems to have arisen in response to competition from mediators, particularly in family law, and to other changing legislative demands. So whether or not this is a positive development is questionable, given that similar ADR services may be found elsewhere more cheaply. So collaborative law sessions, say the authors, require 4 to 7 sessions, and collaborative law came about primarily as a result of 2006 amendments to the Family Law Act, which required compulsory ADR processes. And cynically, the view which is advanced is that lawyers could see the shift towards mediation and less intervention from lawyers as meaning they were out of a job. So they created this collaborative law process as a way of continuing to be involved in the process. That's a view. I'm not suggesting that is necessarily the case, but it's something that you might think about. So think about, are there some real benefits to parties? And arguably in collaborative law, there are some real benefits to parties which are involved in ongoing family or commercial relationships. That is, particularly if collaborative law helps the parties to come to a cost-effective early resolution of their dispute. Okay, well, let's move on. And if there are any questions, please feel free to unmute and just ask the question or use the chat facility. Dispute resolution advisors. Now, this is we'll go back to our sheet. It's number 3 on our list. So this is quite informal. And dispute resolution advisors is intended to be a dispute avoidance process, often at a pre-contract level, takes advantages of an advisor with technical skills, provides the possibility for an on-the-spot resolution, and allows for a collective acceptance of problems. So a dispute resolution advisor is established to be ready to move in and help the parties work through a problem before it becomes a really major problem. But this is all part of the pre-contract planning stage, pre-development. Look, it started in Hong Kong. You probably saw that. It's been employed in many government contracts in Hong Kong. And it's really a way of allowing the parties to resolve conflict rather than necessarily determine the conflict. So it's setting up a procedure so that parties know where they're going in terms of issues that may arise. So it's essentially dispute avoidance process. It comes in at an early stage, and it allows the parties to deal with differences, if you like, before those differences become full-blown disputes involving very expensive lawyers and processes. So it's part of a management tool, if you like. And you might think that it's something that you should consider talking to your clients about at the stage where they're about to move into a commercial enterprise or a commercial project. Do we need to set up a dispute resolution advisor paradigm? As Spencer states at page 133, stakeholders are encouraged to think about problems in a particular project as being not your problem, but this is our problem or my problem. So it's a way of ensuring that parties think about and keep ownership of the dispute throughout that process. So typically the parties will sign a contract. It will provide a flowchart, and in figure 5.1 on page 134, Spencer has an idea of that flowchart, sets out that flowchart, and the dispute resolution advisor comes in and essentially provides a short form of arbitration. And depending on what's in the contract, that short form arbitration can be binding on the parties. So a dispute resolution advisor is different to an appraiser or a referee that you may have read about. Strictly, the dispute resolution advisor is dispute avoidance process rather than, if you like, an alternative dispute resolution process, although there are many similarities. So it is aimed more at building projects, yes, and the dispute resolution advisor doesn't seek to impose a solution in the same way that an adjudicator would or an arbitrator would, but merely seeks to identify differences, helps the parties to avoid the dispute, allows for the matter to move smoothly forward rather than requiring a formal dispute resolution or litigation arbitration. I want to stop and mention that the Australian Competition and Consumer Commission has a number of dispute resolution processes built into its operation. I'd recommend that you look at the website for the ACCC, and I haven't for a while, but I was doing some work for the Office of the Mediation Advisor, as it was then. It's now the Office of the Franchise Mediation Advisor, and so that's worth a look at how the ACCC deals with issues to do with dispute resolution. Okay, any questions about dispute resolution advisors? Okay, let's talk about dispute review boards. Again, we go back to our flowchart. Dispute review boards, okay, they're at number 4 out of 14, so they're still very much at the non-interventionist end with a high level of involvement for the disputants. So dispute review boards are also a dispute avoidance process aimed more at avoiding rather than resolving necessarily the dispute. Again, pre-contract, takes advantage of external panels with technical skills and provides an on-the-spot resolution. It's inquisitorial in nature. So those people that are appointed to the dispute review board are expected to get into the problem and ask a lot of questions. Now, usually the board will have an odd number of people, typically 3, so that there's a way of resolving deadlocks. Again, more commonly used in the construction industry. And again, the simple idea is to keep the lines of communication open, a bit like the dispute resolution advisors. Essentially, a dispute resolution board is a panel of experts, and they're appointed as a result of the contract or agreement between the parties. They are expected to meet regularly throughout the course of the project and involve themselves in potential disputes at an early stage. And in many ways, they're there to assist the parties. Usually their decisions, if you like, are not final and binding, but that can be built into the contract. Because they're usually there to assist with technical issues, of course, the members would normally be comprised of technical experts. But if you're giving some advice to a client about this, you might suggest that it be appropriate that 2 technical advisors be appointed and the third one be a lawyer, perhaps. But again, the same problems that I talked about before would apply when I'm talking about collaborative law. Okay, what happens? Are there disclosure obligations? Are the parties able to be cross-examined? Are lawyers able to be involved in the process of cross-examination, preparing documents, making submissions? So these are all things that need to be considered at that early pre-contract stage. All right, so that's the issue to do with dispute review boards. No questions? I appreciate that I'm doing a lot of talking, but if you have any questions, jump in. Let's talk about partnering. Again, we'll have a look at our sheet. Where's partnering? Number 2. The only thing that is less formal, that involves the participants more, is negotiation. So what's partnering? Again, it's a dispute avoidance process. It's less formal than a dispute resolution board. It's kind of a form of do-it-yourself dispute appraisal or ADR. And again, it's designed more at avoidance rather than resolution, often again at pre-contract level, and takes advantage of in-house advisors with technical skills as opposed to outside advisors, which is normally what happens in a dispute review board. So the parties themselves adopt, I suppose, a charter. And in a way, you could describe partnering as a sophisticated handshake. It's where the parties make a commitment to each other that they will adopt a cooperative culture of mutual trust. But there are some specifics. And the thing about partnering is that usually it involves a number of workshops. And this is all agreed to at the start. And the workshops are organised in a quite specific manner. There'll be an agenda, there'll be a location, there'll be a nominated leader or facilitator. There'll be some team building exercise. It's all to do with identifying what's in the interest of the parties and what are the issues of concern and are there ways that we can resolve these. So it's really something which involves a lot of forethought. It would normally be, to my mind, involved in substantial projects where there are a lot of ground rules set. And even we go back to basics and there might be a mission statement identified. There might be some ground rules set out for communication, and there might be a way to review and reinforce this charter that I've talked about, which is partnering. So it's really quite a sophisticated way of doing things, and it's all designed from the outset to ensure that the parties have this clear and open line of communication. There's set times for these workshops to take place. I think there's a lot to be said for it. Are there any comments about partnering? Can anyone see how that might be useful in practice? So think about that in the context of the recommendations you might give. Yes, sorry, Brett.
Oh, that's okay. Just with the those three processes that you just outlined to us, you mentioned that they're typically done in a pre-contractual stage. Is there so that's prior to either party have signed? Now, in a deal, I know in Hong Kong they employ one of the processes in jobs above 200 million Hong Kong dollars. At that level of project, is there if you're narrowing it down, you've got one at the government and then one contractor. Is there a danger that the disputes that are discussed and discovered during this stage will turn their major contractor away?
Yes, absolutely. It's it always, I suppose, is it probably would be part of a tender process originally, I suppose, or through a heads of agreement from the outset. But yeah, it has the potential to turn people away. I think many people would embrace it. I think most people that are embarking on or representing companies or organisations embarking on major projects would embrace this concept because they can see in the long term the mutual benefits of working cooperatively. But yeah, I accept your point. It may put some people off.
Well, the other issue that I thought about was I noticed the cost to the process can be 0.5% or up to 1% of the total cost of the project. Now, if you hadn't signed a heads of agreement or a contract, a formal contract, you wouldn't want to spend that sort of money on a process that turns a party away. You'd need to be fairly certain that the party you're going to be engaged with is the final one that you want to do business with.
No, I'd agree with that. And again, I would think it probably would have to be part of the overall tender process and discussed right from the outset, rather than being introduced late in negotiations.
Yeah, that makes sense. Yeah, thanks, John.
Thanks very much, Brad. All right, appreciate that. Okay, let's talk about appraisals. Appraisals are number 9 on our list of 14. It's discussed generally in the text. So this is a genuine alternative dispute resolution process. It's generally not binding, and an appraisal is normally undertaken by an expert. It's relatively informal. There are no rules of natural justice in relation to appraisal, no need for a written decision, and the appraiser suggests a desirable outcome, and the parties are able to accept that or reject it. You may say, well, there's a lot of advantages in having the appraisal system because it's quite informal, it's quite quick, because we don't have to pay an appraiser to write a written reason. There's some cost saving. I have some issues with it. I like the idea that it's an industry expert. I think that has a lot of advantages to it. But no rules of natural justice. That always concerns me. I guess coming from QCAT, where we're very big on natural justice, I think it's important. Generally, my view is that it's important that anyone that's involved in the process feels that they have every opportunity to have their say and be heard, which is really a big part of natural justice. Although in an appraisal, it's a suggestion of an outcome, the parties can walk away from it. In that sense, I'm not sure that I necessarily agree that it should be rated at 9 from 14. To me, it's almost below mediation in terms of the number that it should be given. But you might disagree. That's where David Spencer put it in the list of options. So you might have to think about, when would you use an appraisal? When would it be a good time to do that? What type of parties would benefit from an appraisal? What type of dispute would be a good matter for an appraisal? Okay, let's talk about the issue is Audrey's raised the issue about a report might end up in court later. to prejudice a party. So you need to think about that issue as well. So thank you. Expert determination. This is 10 out of 14, so it's quite formal. And an expert determination is an ADR process. It is binding. It's undertaken by an expert. It's relatively informal. It's not governed by legislation, as is the case with, say, formal arbitration. Again, there's with an expert determination, there's no rules of natural justice, and the decision remains private. Okay, so that's in many ways very similar. Expert determination is very similar to appraisal. The next on the list, which is number 11 from 14, is early neutral evaluation. Again, very similar. It's an ADR process, it's non-binding, undertaken by an expert, but normally a lawyer. It's not governed by legislation, and again, no rules of natural justice, no need for a written decision, and the decision remains private. So you might think that that privacy issue is important, and again, need to think about when that might be appropriate. Right, the next one is court-appointed referees. This is 13 of 14. This is the one that's next to arbitration. So it's the most formal except for one. And court-appointed referees was a referencing out procedure. So this is where it's undertaken by a court, typically as part of litigation, and the parties may agree to or challenge some or all of the findings, and the court may adopt, vary or reject a referee's report in whole or part. In that regard, I'd refer you to the Uniform Civil Procedure Rules and also the Civil Proceeding Act. So it is, yes, Catherine has raised the issue, is it similar process to a court-appointed cost assessor? Yes, it's where the court is essentially saying, look, in relation to this particular point or this argument, we want to send it off for a referee to make a determination. Comes back to the court can accept it, or they can reject that, if you like, assessment from the referee. So thank you for that, Catherine. Okay, so you think about those issues in the context of what advice you may give. There are a couple that I don't think they're in the text. I just want to touch on them, and they are adjudication and some options under the criminal justice system. So firstly, adjudication. This is undertaken by accredited experts in an industry. It's usually to do with construction. So have a look at the Building and Construction Industry Payments Act of 2004, and it's used by subcontractors. It's a way of finding a quick resolution, and the powers for the adjudicator are conferred by legislation. Interesting work being an adjudicator. I think people that are involved in that industry enjoy it. So it's quite formal, quite a formal process, very quick. It's, again, part of the industry. And I think the key point there is it's for subcontractors. Keep that in mind. And the final topic I wanted to talk about tonight was criminal justice system. You might think it odd to be talking about criminal law in the context of alternative dispute resolution, but there are options available for ADR processes in criminal law proceedings. In a child situation, the child can be referred to what we call a youth justice conference. At the moment, it can only be done by a direct referral from the police to the youth justice conference convener. And it can only be done in circumstances where the child has admitted guilt, and it's a way of diverting the child away from the criminal justice system in terms of courts to this youth justice conference. And what happens is that it's essentially a round table. The child is there, usually with a support person, parent. The lawyers can be involved as well. Police are involved. There is a youth justice convener, and the victim is there, and people that are associated with the victim as well. And it's an opportunity for the victim to converse directly with the perpetrator, the youthful perpetrator. And the idea, the theory is that the young person gains some insight as to what their actions actually do to people. And in many ways, people think that's a very good idea. It helps in terms of educating the child, but also providing some benefits for the victim, in that the victim now feels that they've had a say, they've had an opportunity to meet the person who committed the crime. I think there's another advantage to the victim as well, and that is it might take away some of the fear. I mean, I guess I see it from the perspective of the child in these circumstances, and I suspect that they're very different to the way that they might present on the evening. So often they're much more contrite, much more reasonable. On the other hand, John has pointed out very correctly, it might reopen wounds for the victim. So I think it's an appropriate mechanism in circumstances where the victim is willing to consent. We wouldn't want to see the victims to come along be forced to attend. So you might regard that as being something of use. There's actually, I think, a video about this. There was some issues in relation to parkour and young people exercising parkour, the free running, etc. And some of the victims enjoyed that process of meeting with the perpetrators. In criminal law matters for adults, there can also be resolution through mediation, and that might be relevant where there are family members involved. Brothers who get into a scuffle when they're drunk, rather than go through the criminal justice system, it may be that the matters are referred to a mediation essentially. And there are some other ways that ADR can be used in domestic violence, perhaps the use of undertakings as a way of having the matter resolved without going through a prosecutorial process. And you might think that could be useful in instances of, say, domestic violence or stalking. Okay.
John,
yes, John.
Today in the court as a JP, I had a lady from the Scrub Hill Farm community, and I was just reading this chapter when it came in, and we were talking generally about how the community functions. And I said to her, do you use restorative justice at all in your community? And she said, yes, they do, very much on an informal basis, with the elders sort of convening a meeting between the victim and the perpetrators. And they said that in most cases, it is very, very beneficial, but not all.
No, thank you for that contribution, John. And I'd agree with that. I think there's a lot to be said for it. And we previously had the Murray Court that was disbanded, but there is talk of that being reintroduced, and I do hope that it is. So the Murray Court involves, for Indigenous offenders, it involves the elders coming into court and being part of that process. So thank you, John. All right, so are there any questions generally or comments about all of these different other forms of ADR processes that we've discussed tonight? Okay. All right, well, thank you very much. I'll stop the recording now, and we'll look forward to further discussions through you, crew, and we'll see you next week. Bye.